Going to about one. Wow, about one.
Welcome to Noon Edition on WFIU. I'm your host, Bob Zaltsberg, and today we're hosting a special program with a live audience at the IU Maurer School of Law, talking about President Trump's recent actions during his first months back in office and the term constitutional crisis. We have three guests with us, distinguished guests, sitting up here at the law school. To my immediate left is Daniel Conkle. Robert H. McKinney, Professor of Law Emeritus at IU, teaches constitutional law, the First Amendment, and law and religion. Steve Sanders, not a stranger to anyone in this room, I'm sure. Steve is a professor of law at Indiana University and a constitutional scholar, and he was instrumental in getting us over here today. And also Christopher Daley, who is the executive director of the ACLU of Indiana. He's been in that job since 2024. And we're happy to have Chris here today as well. If you have questions, as Mary told you earlier, you can send them to Benta. If you're at home, you can send us your questions to news@indianapublicmedia.org. You can also send them to X at WFIU WTIU News. So we have so many questions, so little time. I'm just going to get to the big one first. Dan, I'm going to start with you and then go to Steve and Chris. Are we in a constitutional crisis, headed for a constitutional crisis? How would you define the term constitutional crisis?
Well, I think there are various ways to define that term. In my mind, yes, we are in a constitutional crisis. And the three things that I would point to are, number one, the increasingly direct confrontation between the president and the executive branch on the one hand and the federal judiciary on the other. Second, the virtual absence of any meaningful congressional check on the president at the present point in time. And third, a group of actions taken in the aggregate which suggest a slide, rather quick slide, in an authoritarian direction. To quote Donald Borelli, an attorney in one of the law firm cases, quote, "We're sliding very fast into an abyss." And so just some of those various actions that have been taken, a truly unprecedented attack on law firms, universities, news organizations with which Trump has disagreed, as well as attacks on Department of Justice lawyers, former Trump administration officials who parted company with the president during the first administration. You think back, those of us who are old enough to remember, the secret enemies list that was maintained during the Nixon administration. This one arguably is present, but not so secret, more or less transparent in terms of a campaign. Essentially, Carl Bernstein was here a week ago in the room next door talking about what in his view amounted to a campaign of intimidation. Third, and very obvious thing to think about and worry about is the actions that have been taken against non-citizens, revocation of visas without notice or opportunity to respond, much less the removal of all those folks down in El Salvador, which I'm sure we'll come back to and talk about in more detail. So yes, my answer is yes, we're in a constitutional crisis now, and I hope it can be resolved.
Steve? I agree with everything you said, but to my mind, a crisis suggests an incident or something that has a beginning and an end. I think the problem is we have an anti-constitutional presidential administration. We have an administration that's been at war since its first day in office with the assumptions that the framers designed into the architecture of the Constitution and with all of the constitutional norms that have guided presidential behavior for generations. In February, the White House posted this graphic, the likeness of Trump wearing a crown that said, "Long live the king." That sort of tells you everything you need to know. The framers rejected monarchy. They'd be horrified. What I would expect is a posting on social media from the White House that basically says the Constitution is for suckers. Courts are for weak people and for suckers. Law is for suckers. Because, I'm sorry, that's the way they behave. Whether it is attempting to crush universities or sending people to black sites in El Salvador, this exercise of raw authoritarian power in pursuit of political goals has become the hallmark of this administration. And so I can't speak to whether, any of the people, Donald Trump or the people around him, have read the Constitution and know constitutional law, but they certainly don't act like it based on their day-to-day actions.
Chris?
Very much like Steve, while I don't disagree with anything Dan said, at the ACLU of Indiana and throughout the ACLU network, we are trying to be incredibly cautious about saying when we're in a constitutional crisis. But here's the thing, there's no roadmap for what we're in right now in the United States. If you look at the Civil War, it's probably the closest analogy in terms of the complete disregard, not only for the Constitution and the statutes that are out there, but just the norms of governance. There is an effort to completely reset what it means to have a federal government and what it means to lead a federal government. And I think that what we are is incredibly clear-eyed and incredibly resolute and prepared to not let that happen, whether or not we enter a constitutional crisis or not. I think that what I've been encouraged by is the number of folks, certainly here in Bloomington, but throughout Indiana and throughout the country, who are incredibly tuned in and incredibly worried about this moment that we're in and not knowing what to do, right? I think that is probably the conversation most of you are having is what can I do right now? And so obviously at the ACLU, we're suing, courts are looking at these cases, but just to be super clear, lawyers are not going to save our democracy, right? The ACLU has a role to play, judges have a role to play, but this is really going to be on us at the end of the day to push back against what's happening, to get us back on a regular course, and then to put some safeguards in place so that we don't find ourselves here.
So this is none of you have ever been in a situation like this before. I mean, we're sort of in unprecedented territory. Is there any historical precedent for this?
I mean, my political knowledge doesn't go, I'm not a historian, but, there have certainly been times in recent years with the Obama administration, the Biden administration, the Trump administration, where, they tried to test the boundaries of what the president can do by executive order rather than going through Congress. We had a Congress that was weak and doesn't seem to understand its constitutional role for a while now. It's just that all of that has gotten worse. I think the one thing that's different, at least in the modern era, at least maybe since the you have a Department of Justice that populated by lawyers who actually care about what the Constitution and constitutional law requires and think carefully and tell the president and tell cabinet officials, no, you can't do that for a reason, after performing a competent and independent constitutional analysis. This is a president who has populated those sorts of offices with hats and flunkies, and they are not going to tell the and they see their job as infinite.
So that's the difference between the first term and this term?
I think it's a big difference. Yeah, we would hear during the first term, well, God, you wouldn't believe the things he would do if he were left to his own, but the grown-ups around him, his chief of staff, his secretary of defense, his White House counsel, prevent him from doing these things. I don't think any of us would have imagined that things could be this bad. And you have somebody who's guided entirely by his ear and by his sort of obsession with the idea that he was.
One particular office in the Department of Justice, the Office of Legal Counsel, by their reputation, which did play a good political point piece in leading that office, but it was perceived itself to be, I think, largely it was, a professional office dealing with legal precedents, issuing opinions, those that are being essentially disregarded by the current Trump administration. And as far as I know, the Office of Legal Counsel, should exist, is really doing certainly what it has done in the previous administrations, Republican administration.
And I think the other thing, Bob, just real quick, in this question of what's different now from 2017 in those 4 years, when Trump came in 2017, he was still around the senior side, like around and he did not understand the amount of which the things he was being told he couldn't do were things that were about governance norms and about adhering to court orders and so on and so forth. I think what we've seen is he has completely changed the media landscape, right? So if you just think about who was the predominant media on the right at the time he came in, those folks are obviously still important, but they are not leading the discussion. It is the blogosphere and the startup conservative media who are now leading the discussions among these folks. He faced any number of criminal and civil lawsuits and has come out of them unscathed, at least at the current moment, and ran as a convicted felon and was elected by a majority of folks who went to the polls and voted. He understands all of that and has come in emboldened in a way that I think we did not foresee in 2017. And as well, folks in Congress who are trying to support him are emboldened in that way, and the United States legislature is emboldened in that way. Essentially, what he touted in 2017 has now become the norm across the state and many state legislatures, and folks feel that there is no consequence to his bad behavior, his bad governance, and so there are now, again, there's just no guardrails in terms of what he's going to do.
Along those lines, I did want to ask, because Todd Young was in town this week, Senator, and he actually made a statement to people at a Chamber of Commerce event that when he goes around the state, goes is popular with about 90% of the constituents of Indiana. What do you make of that?
Some of it is, I think, except for the people who have relatives who have been laid off, the friends who have laid off, that laid off by federal agencies. There are increasing memes on social media, people saying, I voted for Trump and I didn't think that my uncle was going to get laid off from the federal government. So some of that is going to catch up. But I think it's because we have a country where civics education has long suffered and where people have come to see politics as sort of reality TV. Things that we spend our days thinking about, judicial review, the courts, what the framers thought that balance of power would be between the legislative and executive branch. That is something most people are interested in, haven't learned about, and care to learn about. And so, they just assume that the president has this authority for tariffs. It's Congress that has the authority for tariffs, but Congress isn't doing anything to stop this abuse. So, I think a lot of it is just that people are attuned to seeing this as a TV show. Since the 1970s, since the Nixon administration, we talked about an imperial presidency. Now, this is a different order of magnitude of that, but we become accustomed to the idea that the president is this powerful figure over the entire
I think the other thing is the lack of any sort of nuanced understanding of what George is doing. Basically, there is I would guess, if you go back to Ronald Reagan, a conventionally conservative point of view. The federal government's bloated. You had huge amounts of spending during the Biden administration, in particular, like the Trump first administration in response to COVID. So that if and to the extent that DOGE translates to some voters' minds as, yeah, let's cut this federal government, then I think that would be certainly a conventionally mainstream opinion, certainly on the right side of the political spectrum. And I think some folks thought, myself included, that DOGE, when it was being talked about, would have meant, you know, you'd have people who would in fact do some kind of a study. What kind of government cuts can be made effectively and maintain appropriate services, rather than what amounted to essentially a slash and burn approach by Elon Musk and those with him, without any apparent study to go along with it. So I think it's sort of just, it goes in keeping with what Steve was saying, I think, in terms of minimal, at least in-depth understanding of what's actually going on, and the absence of any congressional response from an institutional point of view, at least so far. Not may yet happen that Congress may in fact step up at some point and say, wait a minute, you know, we're not part of plants, maybe we have some role to play in the federal government.
Get into this conflict between the executive branch and the judicial branch. A lot of the lower court judges have said that many of these orders are unconstitutional. And Trump, at some points, is seemingly ignoring these orders. There's a lot of chatter among people who support President Trump. I've heard some of his, I think his press secretaries say, you know, why should a judge be able to tell the President of the United States what to do? So as constitutional law experts, why should a judge be able to tell the President?
Just let me just say, I mean, this echoes a famous line of President Nixon. When the president does it, that means it is not illegal. So there's some sense of that, I think, in what Trump is doing. I think that you have basically a fundamental conflict that is brewing, especially in the immigration context. Folks, I'm sure, are aware of the Abrego Garcia case, in which the individual from Maryland was mistakenly caught up in the deportations that ended up in the prison in El Salvador, despite a prior order that was protecting him from removal based upon concerns that he would in fact be victimized by gang violence himself if he will return to El Salvador. But this case and its development highlights this issue of conflict between the president on the one hand and the judiciary on the other. Supreme Court ruling last week is the one, again, it's been in the news, basically approving the district court's giving of relief to Abrego Garcia, but clarifying that the government was required to quote-unquote facilitate his return to the United States, but not necessarily quote-unquote effectuate his return, with the Supreme Court also saying that the district court should give due regard to the deference owed to the executive branch in the conduct of foreign affairs, even as the government should be prepared itself to share information about the steps it's taking to bring it back. Okay, well, on remand, back in the district court before Judge Guinness, I think it's the correct pronunciation, basically the government says, we don't have to do anything. Facilitate can be entirely passive, and you saw, no doubt, the televised appearance by the president Daley of El Salvador, the president Trump looking on, basically saying, we're not bringing this guy back, and the president is basically likewise saying, through the administration, we're not going to do that. Judge Guinness is basically trying to order the government now to do things, explain yourself, what are you doing to, in fact, effectuate his return to the United States. More significant, I think, and directly in response to Bob's question about the role of the judiciary, there was a very, very notable opinion issued just yesterday by the U.S. Court of Appeals for the Fourth Circuit, written by a judge, Judge Harvey Wilkinson, appointed by President Ronald Reagan, obviously a conservative Republican president, approving and refusing to refusing an appeal against the district court's ruling against the government and describing this unanimous opinion for the Fourth Circuit panel, critiquing the government's assertion, I'm quoting here, of a right to statutory residence of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, there is nothing that can be done. This should be shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from the courthouse still hold dear. It's a conservative judge speaking, I think, quite powerfully, concluding his opinion with the following. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents a unique chance to vindicate that value and to summon the best that is within us while there is still time. For the note of urgency in the judge's opinion, consistent with my suggestion that we're not in the constitutional crisis yet, we're about that far from it.
I think that the media coverage suggests that, well, the president has his view whether the judge sides with the administration or not. They're just substituting their view and their opinion for the president. If that were the case, then I would have sympathy with that argument. But, the very first case that I think Dan and others who teach common law teach is Marbury versus Jackson. Very early days of the Republic, written by the first great Chief Justice John Marshall, in which he said, there are areas where the president makes policy decisions, what shall our foreign policy be, and so forth. And judges don't have a right to, and it's not the role of the judiciary to interfere with that. But in other areas where the president is carrying out statutes and is carrying out responsibilities, he is an officer of the law and is accountable to the law. What judges are actually doing when they decided these cases, that again doesn't get conveyed to most people, is they are measuring presidential actions or congressional actions against either the text of the Constitution, the text of a statute, or more likely an accumulation of judicial precedents from the Supreme Court and other courts to try to determine as carefully as they can, is this action consistent with the law? Is this action consistent with the Constitution? Again, the framers and the writings and places like the Federalist Papers said, when you give life tenure to judges, when you allow judges to do judicial review, you're not doing it because they're smarter or better capable or have better character than judges. We're doing it because we need some umpires to determine whether or not those actions are consistent or not consistent with the law.
Well, what I think is important to note here is folks who are critiquing whether or not a district court judge can do a nationwide injunction, they don't care about that. They applauded when district court judges did that to President Biden. The vast majority of folks who are speaking on behalf of this administration do not care if they believe, do not expect to believe, to be believed. They are saying things that they think serve them in that manner. And I think the bigger question for us, right, however we get out of this moment, what does that mean to us? So if we have a president who has, from this particular perspective, has largely neutered the judiciary and their ability to check a president, well, it's not as if we're not going to have a president from a different perspective later on. And there is no concern. Now, this is when we talk about the difference between being an institutionalist or being someone who wants to expand presidential power, it's always a short-term. There is no sense from these folks right now that they are going to get out of power at some point, which they will. And frankly, they believe that whoever follows them will not, and this is what Steve was saying earlier, will not have the courage, right, to put it as politely as I can, to buck the system in ways that the current administration is doing. I don't think that holds, right? There is going to be a point in time where the system is so degraded that when folks who were institutionalists come in, and listen, Senator Young was an institutionalist, I think he probably still wants to be an institutionalist, but that is not the moment he is legislating in right now. And the question is, what comes next? And I think that as tragic as what's happening right now is, where this takes us in 5 and 10 and 20 years, again, is uncharted and probably
I would commend the people of David Brooks' column in today's New York Times, which basically on one hand is saying that the resistance to Trump, he just used this term, but essentially suffers from a collective action problem, and there needs to be some kind of concerted effort to in fact resist. But beyond that, if you read the column to the end, he's also suggesting that whatever comes next has to in some way politically accommodate some of the concerns that may be legitimate that are coming from the supporters of Donald Trump. Brooks in particular mentions higher education as being to an undue degree dominated by what he calls, I think, a stifling progressivism, and that somehow any new regime of governance basically has to somehow bring people along in a way that makes for a new political accommodation and not simply the status quo ante of what we had before this came about.
On the area of higher education, I know, Steve, you mentioned the unconstitutional pressures and penalties being directed at universities. Can you talk more about that?
Just yesterday, the Constitutional Law case where the Clinton administration, Justice Department, sued Virginia because of the VMI military academy of single sex, and the argument was that was a violation of the Constitution. But the Trump administration is saying is that Harvard and these other universities are violating various civil rights laws, specifically laws intended to protect Jewish students, in a normal time, in a normal administration, the way you do that is you send them a notice, and you ask for information and evidence, and maybe if push comes to shove, you sue them in court to force them to comply with the law. Instead, what we have is this overwhelming shock and awe of we're cutting your funding starting tomorrow, billions of dollars, plus we're demanding that you fire this professor and disband this student organization and implement this policy, things that go completely beyond any immediate necessity to if the university is violating. And it's that attack on the ability of a knowledge-producing, expressive institution to do its job as it sees fit that is one of the first things.
And the doubling down, if you're reading things about Harvard in particular, Harvard indicates it's going to resist. What is the response? From President Trump, well, let's see if we can get rid of the tax-exempt status. Maybe that will, in fact, bring them to their knees. More recently still, if you read this morning's paper, I was talking to Bob earlier, it took me a couple hours just to read through the papers today to see what happened in the last day. New York Times has this weekly feature, This Week in Trump. You really mean this day in Trump, this hour in Trump. In any case, most recently, now the government demanded data from Harvard on its international students as to whether they've been guilty of any illegal conduct, or they've had any disciplinary action, are they taking enough courses to in fact justify their student visa and the like. So it's a doubling down by the Trump administration, again, in the pressure campaign. And you can also see in that context, Bob, and in the context of things like law firms, is the impact not only on the institution, or in the case of law firms, not only law firms, but on their clients. So there is kind of a double whammy for the targets in terms of not only standing up for themselves, but how do we also take account of the interests of those to whom we have particular obligations, including our students, intensifying the pressure to, in fact, acquiesce in particular.
And this is a good administration that understands a few things. One of those is how to exploit weakness, how to target weakness. Universities have been defensive for some of the abuses that David Brooks talks about, and other things out there about this. So, again, when you are in a defensive crouch anyway, and when you're under attack, it makes it harder for you to stand up for your rights and to expect the public or these intellectual and civic and leaders to come to your defense.
And unfortunately, it's not limited just to law firms and to universities. nonprofits in Indiana who have federal contracts very quickly after the first executive order of the Trump administration attacking anti-discrimination programs, right, which is really what the diversity, equity, and inclusion is, trying to fight against discrimination. Received letters from their agencies that hold their grants explaining, again, as Steve said, in minute detail, things they needed to take off their website, changes they needed to do to their buildings, programs that they needed to eliminate, whether or not those things were in any way connected to the funds that they were getting from the federal government. Obviously, the state of Maine is under a lot of pressure, both directly from the president, directly to the governor, but then based on funding. At the same time that the states that the Trump administration is targeting for financial consequences, at the same time that's happening, these are oftentimes the states who most contribute monies into the federal coffers. And so we're even seeing that flip on its head, that they are using money that's come from taxpayers in those states to attack those states and then withholding the disproportionately low amount of money they get back from the federal government. And I think, again, this is part and parcel of who President Trump is and the way in which he now sees the federal budget, which is beholden to him and his point of view and scores he wants to set.
We have a few audience questions I want to get to. There are a couple on this that follow this theme. Federal court fines an official from the executive branch in criminal contempt. How is that enforced if the executive branch refuses to cooperate?
Courts are very reluctant to hold litigants in contempt or try everything they can to avoid reaching that point. But basically, the tools are twofold: fines and jail. Sending a federal official to jail if they refuse to comply. We had a speaker in a workshop a couple of weeks ago exploring an interesting fact that the U.S. Marshals, who are the people who would actually take someone into custody and put them in jail, are actually accountable in the government's organizational chart to the Justice Department, raising the possibility that the president could say, no, I'm ordering the Marshals not to do that. Alexander Hamilton had a point when he wrote in one of the Federalist Papers: the judiciary is the least dangerous branch. It has neither force nor will, it has only judgment. It even depends on the executive to enforce its orders, the way Eisenhower did after Brown versus Board of Education. He didn't like the decision, but he enforced it. He used federal troops and resources to enforce it. So the short answer is fines and jail, assuming that the U.S. Marshals aren't put in a situation where they have to choose between their loyalty and their duty to the courts that they work with day in and day out, and the fact that ultimately their boss is the Justice Department and ultimately the president.
The other thing that is extremely significant to note is that there's a Supreme Court case saying that prosecutions for criminal contempt are subject to the presidential pardon power, so that anyone who is prosecuted for criminal contempt can be relieved of that by the circumstance from Donald Trump. Despite that, you do have, not in the Brigham Garcia case, but in the broader challenge that was brought for the Venezuelans who were shipped off by plane to El Salvador, there is a ruling just this week from the judge in that case, the D.C. Circuit Judge Zaltsberg, if I have his name pronounced correctly, finding probable cause to find the government officials in criminal contempt based upon earlier, when they were shipped there, by every indication the planes were already in the air, and there's some ambiguity, gave an oral instruction to bring the planes back. The government did bring the planes back. He later had a written order that didn't specifically say bring the planes back, they're already in the air. Anyway, he's basically saying that this, in my judgment, probably is going to contempt, asking for further inquiry and instruction. But again, if we move forward with that, it could be subject to probably Steve case, also the potential for the presidential pardon. Conversely, there's another concept that is known as civil contempt, which is more forward-looking, basically designed to say either you comply with this order or you'll be subjected to fines or imprisonment. That, by invitation, is not subject to the party power. The problem for this judge is that, based on a previous Supreme Court ruling, he had been deprived of continuing jurisdiction over that case. The Supreme Court saying this challenge brought by the broader group of Venezuelans should have been brought technically in a habeas corpus proceeding in the district where they were most recently detained. And that was not the District of Columbia. Instead, there the claim was brought under the Administrative Procedure Act. Supreme Court says you picked the wrong forum based on the wrong legal procedure. So basically, Judge Blasberg is basically saying implicitly, I can't do civil contempt because I don't have control of this case anymore in terms of forward-looking compliance. But these guys, the U.S. Executive Department officials, should be essentially punished for evading my efforts to, for evading enforcement of the orders that I issued when I did have the authority to decide those cases.
And I think, sorry, Steve, I think what's super interesting to me is if we think of the federal workforce, these are our neighbors. These are people who graduate from IU. These are people who are members of our family. And I think one of the stories that is not yet being told is the coercive nature of what's happening within the federal government and how that's affecting these folks, right? So I think there's an assumption of those of us who oppose what's happening around immigration enforcement that the on-the-ground officers are 100% behind it and feel good about it. And I just don't think that's anywhere near true, right? So same with the marshals, who would be ordered by a judge to arrest someone and then ordered by the attorney general or the president not to do so. And there's going to become a moment where these folks have to decide whether they're going to step up or not. And that is something that, as a director of the ACLU, where I literally get paid to step up, is so easy to say. These are folks with families and bills and mortgages and careers that they've sunk 15, 20, 30 years into. And we're asking them to step up. Now, that is something that is going to happen. We have obviously seen that in a number of cases. Dan brought up the Emeritus Garcia case. One of the attorneys who was involved in that case was fired because I believe his defense was not vigorous enough. Right? And literally all he said was, "We messed up," right? Which was factual and true. And that's the moment that we're in. Folks doing the base minimum of competency in their jobs are being seen as disabled. And again, and I hate to come back to this, but what is that going to mean if we hollow out our federal workforce of folks who do believe in institutions and do believe what's happening right now is wrong, and we leave in those folks who are willing to or excited about executing what we think are these illegal and unconstitutional orders? What does that mean for us over the next 20 years?
Right, I think you hear well, there's civil contempt of the marshals for those taking the custody, and the marshals report to the president. There's criminal contempt, but the person who will prosecute that is the Justice Department, and they report to the president, and then the president can pardon them. You know, you get the impression that, well, the president holds all the cards. We're having the checks and balances, and I think this just really underscores the extent to which the framers and also the, in recent years, the Congress, the conviction marshals and so forth, assumed that the presidency would be held by somebody who would act in good faith, who would care about the law and the Constitution, who would act in good character. When Congress gave the president some limited tariff emergency powers going back to the 1970s, we clearly didn't imagine that we could use the today. Once again, the Constitution gives the power of tariffs to Congress, not to the president. So this all falls into the broad category of what we call constitutional norms, and all of the assumptions of behavior, character, and good faith that are integral to the Constitution.
So I think that's a really key point. We have a Constitution that has survived for all these many, many years, precisely because there have been constitutional norms. There has been an understanding that there would be a modicum of good faith and reasonableness by the various branches and the conflicts that exist, which has seriously been jeopardized under the Trump administration. You also have, and I'd like to make a further comment, and that is you have, in terms of a drift toward authoritarianism, a think it's significant the tone that is communicated from Washington, the tone that comes out of the Trump administration and President Trump in particular, that seems to be lacking not only in compassion, but in respect, not only, excuse me, not only for immigrants who may very well have been wrongfully deported to a notorious prison in El Salvador, but also for adversaries internationally, but even allies internationally, in Seoul and Canada, for example. So you have sort of the tone, and if you look at the TV depiction of President Daley of El Salvador, with Trump looking on, I find it to be problematic in terms of the two of them seemingly in agreement that we really don't have to worry too much about what these courts are saying as an implicit signal coming out. Again, sort of a tone of authoritarianism that I think contributes to where we are with
So there's so many different directions I can go. I'd like to go. We only have about 12, 14 minutes to go. I do want to say this. Ben Bouvier, our producer, talked to Mary Beth Tinker this week from the Tinker decision. I'm sure you all teach about. She talked about how we have to remember history. This is the first time we've had a constitutional crisis. She said when the Brown decision happened in 1954, entire counties in Virginia refused to follow it, just shut down the entire school system, sometimes for years. So constitutional crisis is nothing new in our country, but the public has to speak up and take a stand that you cannot.
In the Constitution makes provisions for federalism, the relationship between federal governments and the states badly over the years in lots of different contexts. But in that situation, the Supreme Court came out with Cooper versus Aaron, underscored and said, you mean it, states do not have the right to resist our decisions. They held federal courts when schools, districts tried to create the rules like, well, we're just going to shut down all the public schools rather than comply with that order. Federal district courts and ultimately the Supreme Court stepped in and held the violation of the 14th Amendment. As I said, Eisenhower, despite his grave reservations about the Brown versus Board education, used federal personnel, troops, resources to enforce it. So, this massive resistance may have been a constitutional crisis in some sense, but I think it's possible to say that every institution, every arm of the federal government, the federal constitution, operated the way it was supposed to.
One of the questions that we just had is what is the role of the Supreme Court in their decisions in this? And I would add, we've had Trump versus the United States decision in which the court determined that presidential immunity from criminal prosecution presumptively extends to all the president's official acts. Is that further emboldened them? Is that decision?
Clearly. That's clearly true. And in terms of what the Supreme Court's role is, and what it has been so far, is mainly very narrow technical rulings. They may not be able to avoid a more substantive ruling at some point, maybe rising out one of these cases from or involving El Salvador. And I would hope, maybe, that they might echo the judgment of earlier Harvey Wilkinson of the Fourth Circuit. But who knows?
What do you expect when they announce that they're going to hear the administration's executive order in birthright citizenship? What do you expect about it?
I mean, even with the current makeup of the court, we certainly expect them to hold that executive order to be unconstitutional. The question, I think, comes in, as Dan was alluding to, some of these more situations where they need to be more forceful, right? And so Brown v. Board is such a good example with all deliberate speed was the Supreme Court's way to, in some ways, preserve their legitimacy, right? So they didn't say you have to do this in 180 days or in a year. And there were school districts who took, a decade or more to kind of fully effectuate that ruling. And so I think that what we will see, and I certainly was happy to see the Chief Justice step out, 4 weeks ago or so in defense of the judiciary. I think we will see them checking the president, but doing so in a way that saves as much space for him as possible and gives him as much room to maneuver as possible, both because I think there are people on the court who him to be doing what he's doing, but I think also the court in and of itself is trying to preserve some legitimacy.
We try to read tea leaves like this. The fact that they granted expedited review, they're going to hear this case, a set of cases coming up, these appeals on faster than usual, still that they fast track it, suggests to me that they do realize that they need to step in and correct the errors.
The other thing is, the issue in that case is the broader issue, technical issue, maybe, as to whether or not a district court judge should have the authority to issue a so-called nationwide injunction, not limited to specific parties or the territory that that judge has authority for. And that, I think, is the main base on which the request for state court intervention was granted. I don't know how they would avoid reaching the merits of the issue and focusing only on that part of it. That's been a contested issue potentially for quite a while.
We're talking a lot about courts now and how the judicial branch might be able to step in on a lot of these things. I had a quote from Justice Sylvie, a professor of law at Boston University School of Law, who says, courts have never, ever been the branch of government that saves democracy. Ever. It is really misleading to think about the courts as a savior. She goes on there. Reaction to that?
I think that may be true, but I think courts have a role to play. And it may be, that we do need to have Congress eventually have something to say about this, and the general population. I think that Trump does look at opinion polls, and it could be that some of the things he's doing now may cross the line even for some of his existing supporters. We'll see.
Yeah, maybe those of us who teach criminal just are too judicial centric. But I think that the those type of things where you have Supreme Congress that wasn't doing anything, and Truman tried to seize the steel mills, and Truman got them in the court that could do that. Versus Board of Education, and other decisions like that. Courts made that way. So if the courts aren't going to do it, then it's Congress. We haven't talked about Congress. We haven't talked about once again, the Federalist Papers, the framers said, the design of the system we're setting up here is that ambition will check ambition. The loyalties of members of Congress will be to the institution, not to the political party or to the president. So, but really part of this is simply the failure, lack of ability, lack of will, loss of institutional muscle memory by the Congress to play very meaningful role. Again, so many of the things that this administration is just stepping into it and doing are the proper role of Congress. That the Congress, the majority is happy to see their role as the supporting courts behind the president, and in no way conceptualize the job as a truly independent branch of government.
Another listener has asked, we only have about 5 minutes. So what is the biggest piece of that this panel sees as a group of legal experts not being elevated to a larger conversation that you'd like others to know and be aware of?
I think it's been talked about a little bit today, but just the overall threat to free speech. That the underpinning of so much of the actions by the Trump administration are based on disagreements and going after people who disagree or oppose him. And I think that what we are going to see is, for instance, the international students whose social media was being looked at, or things that they wrote were being looked at, and that's why they were being targeted. That's absolutely not going to stop if folks are here to study or here to immigrate to live. It's going to absolutely extend to citizens of our folks. And so I think the underlying issue with free speech is really, for me, what has a lot of elections.
But notice how much free speech can be affected by things that are not technically criminal prohibition. You can move against the law firm based upon the representation of I'll put it in the executive order, the failed candidate Hillary Clinton. You can move against the law firm because it represented the Williamson company that wanted to sell the Fox News. They actually had gotten relief temporarily, at least against that. But there's a lot of intimidation that can, in fact, disrupt speech, silence critics, even apart from formal legal actions.
And what about the idea of voter suppression? We've got a couple questions about that, and following when President Trump new executive order that required prospective voters to show proof of U.S. citizenship to vote. We have in Indiana, Mike Blunt signed a bill that says student IDs will not be accepted as identification to vote. Who can step in on this?
I mean, a lot of it is not a new story. The Supreme Court, some time ago, held elements of the Constitution, they were just students who were part of that community, so read it as though they were students, some of which were these laws were citizenship, sort of like, I'm mindful of this as so much of it is like being a citizen. Very happy to be a U.S. citizen, but this is part of the authoritarian framework, creating the distraction that makes people obsess and think about and worry about issues that are really not issues. But it stirs people up, it keeps them occupied, it keeps them talking about something while the administration goes off and does other things.
This is one of those issues. President Trump said in March he wasn't joking about the idea of running for a third term. When we'll stop it.
Well, I mean,
Looking to our senior colleague here.
there is a linguistic argument, very technical, that could be made in favor of this. Basically, you cannot be elected to a third term, but maybe you could serve as a third term. Maybe Vance runs as like Russia did, under Putin. Have somebody else run, and then Trump resigns. There's provision 12th Amendment that argues that's not proper. There's also an issue of whether Trump actually tried to do it. There's a legal doctrine that the Supreme Court sometimes embraces called the political question doctrine. Not that any political question is off limits, but that some things have to be resolved outside the court system. The court proceeding could say, well, that's a political question.
He won't get involved in that. You've got state election officials that could get involved, whether he could get on the ballot. Again, it could be a attempt at distraction. You know,
I think
so
we
like-
ultimately depend on the idea that it has to be, have to be the military, literally, frog marching him out or carrying him out. Who controls the military? Not the Supreme Court, not the Congress, the president.
And if anything like this happens, we'll be back here at the Maurer School to talk about it. I want to thank our guests today, Steve Sanders and Dan Conkle. And Chris, thanks for coming down from the ACLU. And also, I want to thank all the help we've had from the Maurer School, from WFIU, WTIU, our producers, Benta Boutier and Pat Bean, our engineer, Brock Hammond. I'm Bob Zaltsberg. Thank you all for attending.